Giovanni Mack? Yes, ma'am.
Mr. Koch?
Judge, this is Miss Giovanni Mack in 24 CF 1103. I believe this is AJ?
Yes, it is. Your Honor, we have not had time to sub the victims on this and speak with them, with us being in pretrial Monday. And then I had the homicide in Jackson County, as well as drug court yesterday. So if I can, the state is going to request a 1 week continuance of this until next Thursday, Your Honor, for us to have time to sub the victims and the law enforcement officers.
Okay. Ms. Mack, I think this is the first time the state's asked for a continuance on your case. I got to be fair to them the same way I will be to you. So I'll see you back here a week from today. So it's going to be in the afternoon?
Yes, it's a pretrial detention, Your Honor.
Okay, gotcha.
So it's
okay.
Continuing.
Wait, Ms. Mack, let me get my right file. Okay, that, Ms. Mack, little different scenario. It's a newer statute that came into play, and so everything's really truncated. It's a lot quicker. So certainly I grant the state's motion. So I'll see you next week.
Judge Carrie Walker was actually transported by EMS from our booking facility, so she is not.
Okay.
And I believe Mr. Cap is on the floor.
Ms. Jacob, I was just informed that Ms. Walker was transported by EMS out of the courthouse, so she won't be here this morning or this afternoon. To the state, are you seeking pretrial detention for her?
No, sir.
Okay.
Your Honor, I'm sorry, Judge, I don't mean to interrupt, but I did want to just simplify this process a bit. I spoke with Mr. Snell about this case earlier. This is a case that the warrant actually had a third-degree felony on it, but somehow when they did the warrant service, they changed it to a trafficking charge. So it should have actually not been on the pretrial detention docket. Mr. Snell and I spoke this morning and agreed to a $2,500 cash or professional bond. I can say pretty confidently Ms. Walker probably would not object to that. So I would ask that the court go ahead and do that without her present.
Okay. Yes, ma'am. The bond's set at that amount.
Thank you, Your Honor. I will provide the court with an electronic order.
Thank you, ma'am.
What about for count two?
Okay, what about count 2, Madam Clerk saying?
And I apologize, Judge. I just got an email about this yesterday afternoon from the PD's office, and I may just pause for a moment to look at what count 2 is.
I believe it's a used two-way communications device.
Would the state agree to a $1,000 cash or professional bond on that one as well?
Yes.
Okay, so that's the bond on count 2. Thank you, ma'am.
Here, and I will provide an order for both charges.
Okay, thank you. Okay, who's going to be next?
Joseph Wallace,
Thank you.
also represented by Mr. Jake White.
Okay. Mr. Wallace, your attorney's on the screen, okay, but you can stand at the lectern. What is the state seeking regarding Mr. Wallace?
A 1 week continuance, Your Honor, to line up witnesses for a hearing.
Okay. Mr. Wallace, this is a relatively new statute. It just came into effect this calendar year. Requires everything to happen really quickly. And the statute also contemplates the ability for the court to continue the hearing, this hearing, because everything is supposed to happen so fast. Because the state isn't ready for the pretrial detention hearing, I will continue it 1 week, so I'll see you on Thursday, okay? Thank you. Thank you, Ms. Jakewood.
Thank you for allowing me to hear back from Judge.
Yes, ma'am.
Thank you.
Okay, I believe that's all the pretrial detentions, right? Okay, we're going to finish up the morning.
Yes, Judge. Nicholas Schneider will be first.
Thank you.
Hey, I cannot deny my case.
Okay, what's your name?
Jaden?
I'm sorry, your last name is what?
Oh, my last name's Pat, and then my first name's Jaden.
Okay. You're,
It's going to be 24 CF 774 Jaden Spatz,
Yeah, he's
SP.
my case is all.
Spatz,
He's
okay,
on 130 docket, Judge.
okay. Okay, so Mr. Spatz, is,
Yep.
So your client, yes.
Mr. Koch, your attorney, is coming to the lectern.
Yes, Mr. Spatz is present virtually. Your Honor, he is here for arraignments. I do not know if information has been filed.
Madam Clerk?
At this time, now that I look at this, it hasn't been filed. The state is going to no cross the case.
Due to insufficient evidence, it's 24 CF 774.
Okay, Mr. Spatz, can't get any better than that from your perspective. The state's dismissing your case, okay?
That sounds great.
Okay,
Thank you, man.
thank you, sir.
Yeah, bye.
Then the other gentleman that's on Zoom, what's your name?
Shannon Younger?
Mr. Younger.
Yes.
Mr. Younger, were you on the 1:30 docket or on the morning docket?
Sir, I'm on both. I was on the 9 and the 130, and they asked me to ask you to do them both on the
Yep.
9.
This case, 24 CF 826 was previously dismissed.
Okay, so does he have any case?
Not on this document, check.
I'll tell you that. We'll go to the podium.
Okay, and Mr. Koch, if you'll hold on 1 second. So, madam, you're fine, you can stand at the lectern. Okay, your case was dismissed by the state, so you don't have a case anymore, okay?
Thank you, sir. That's Mr. Younger?
Yes, sir, correct, that's what the clerk tells me.
Yes, you have a great day, sir.
Thank you, sir, you too, Mr. Younger.
Thank you. Bye-bye.
Bye. Thank you. Okay, Mr. McKinney,
But I want to fix it because the one wasn't across me yet.
okay?
On how much time he got in or how much probation. I don't have the answer to these. Not an obnoxious number. Just more than once.
Mr. Koch?
Yes, Judge. Your Honor, this is going to be an admission. David, he's got, it's, everything.
Sorry, Judge.
Good.
Substance abuse.
Okay. And then can we just write that on, underline? Yeah. Okay. We'll pull that.
You smell
No.
For the court's benefit, Mr. Schneider's question relates to some misdemeanor cases that I think they've already resolved
Good.
this resolution.
I apologize.
Excellent.
There it is. I got that. That's good. Yes,
There's plenty of time to get everything done.
you're all set to go, David? Okay.
We did get this figured here?
Correct. Your Honor, we're here for the VOPs. It's 22 CF 1860, 23 CF 870.
And this is who?
I'm sorry, Judge. Nicholas Schneider.
Thank you.
For the felony case numbers, it will be admit, credit for time served. There's $200 in the VOP cost prosecution, $250 in defense costs. He will be reinstated to finish off his probation. There's also to include a substance abuse evaluation and any recommended treatment. If you can sign right there.
So it's a modification?
Yes,
of
Judge.
supervision. Okay.
And then in case number 24 MM1357, which was a new law, we'll be entering a no contest, adjudication of guilt, and credit for time served and court costs in the misdemeanor.
And then the PD fee for that?
Yes, Judge.
$50?
Yes, Judge.
Okay.
And David, if I have your signature.
Mr. Schneider, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
No, it's reinstated.
Okay, that's fine.
Okay. And what is that? Judge, if I may approach?
Yes, sir. Thank you. Has Mr. Schneider previously been adjudicated guilty of are these, one of them's a felony, right?
They're both felonies, Judge, yes, and he has
Okay.
prior adjudication of guilt.
Okay. Mr. Schneider, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Outstanding. Yes, sir.
Good. Are you satisfied with his representation?
Completely.
Did you sign the plea agreement?
Yes, sir.
Mr. Schneider, I do accept your plea. You're adjudicated guilty in both cases. You're sentenced to credit for time served on the misdemeanor case. You'll need to pay those court costs, $50 public defender's fee. Mr. Koch, do you want that amount rolled into the supervision on the other case?
Yes, please, Judge.
Okay. Mr. Schneider, do you want those amounts where you can pay them during your probation? The amounts on the misdemeanor case?
Yes, sir. That's fine.
Okay.
Yes, sir.
So in the felony case, you're sentenced to credit for time served. You'll need to pay the $200 cost of prosecution, $250 public defender's fee. Your supervision is reinstated and modified so that you'll need to submit to a substance abuse evaluation within 30 days from today and begin any treatment if it's recommended within 60 days from today.
I just have one question, Your Honor.
Yes, sir.
The 2 years that I was on probation, I only have a year left, correct? Since I already did a year?
Whatever probation's not, and yes.
Okay.
Okay?
Okay.
Thank you, Mr. Schneider.
Thank you,
Best
sir.
of luck. Yes, sir.
Yes, sir.
Not yet, I'll ask them in just a second. Please, Ms. Seals?
Thank you. Good afternoon, sir.
One case here, one case.
Sorry about this. Yes, this is Mr. Cleefus Seals, Judge. We have the 22 CF 932, 22 CF 1058. We'll be entering a denial to both those violations of probation. And Judge, if we can put him on that June 10th in the morning.
Okay. Mr. Koch, have you met with Mr. Seals
No,
before?
Judge.
Okay. How long have you been on his case?
Judge, can I all about my computer?
Well, just, you know, when you didn't recognize him when he came out, my antennas went up. So you're going to see and meet with Mr. Seals when?
Judge, I'll see him this week.
Okay.
Either, it could be including this weekend, because I gotta go to the jail. But
Okay.
I'll see him this week.
Mr. Seals, the next date I have similar today, well, I've got next week. Do you want to do him on May 23rd, or do you think?
Judge, I'll see May 23rd, if we can.
Okay. Mr. Seals, I'll see you back here in a week, okay? On May 23rd that morning.
Thank you for your concern.
Yes, sir, you're welcome.
Judge, may I approach with Mr. Snell?
Yes, sir.
Car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formal Wear, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook.
So
at
on
the Cottage
Wendell
Boutique.
Wright's case that's scheduled for 2:30 this afternoon, 20 CF 3187, it is continued until July 11th. We're doing that in the afternoon, I take it?
Yes, Your Honor, 2:30.
Yes, sir, at 2:30.
And his
Okay.
remaining 2 cases, which are set for Monday, we're asking for continuance until the July 8th pretrial.
Yes, sir, those are continued until July the 8th. Mr. Wright knows what you're doing,
Yes, Your Honor, I met with him yesterday. He's been fully apprised.
and he agrees with it.
Absolutely.
Good. If you'll let the jail know.
I will, yes.
Thank you, ma'am.
Thank you, Judge.
Thank you.
Terry Stone is next. He's on both the morning and the 1:30.
Okay, thank you.
Right now.
One second. Judge, this is Mr. Terry Stone. I'll first address the VOPs. The 22 CF 1044, the 23 CF 328 will enter denial in both those cases, Your Honor. Now, focusing on the new law violations, I have 24 CF 695, 24 CF 696, and the 24 CF 703. Just reviewing the information that was handed to us, it looks like all those cases they were filed on, Your Honor. We'll be entering not guilty, waive formal readings. If we can keep all these cases together, Judge, my client is set on July 8th for
Okay.
pretrial.
Mr. Stone, I'll see you on July 8th on all of your cases.
Yes, sir. Thank you, Judge.
Thank you, sir.
or the weekend. Take this with you, but now we know. Okay. Yep.
We're going to recall Tamala Smith.
Okay.
Yeah, it's not working. It's not working.
Yeah.
Yeah, that's working.
Hello again, Ms. Smith. Yes, sir.
Yes, Your Honor. We were set for a bond hearing this morning, this morning. In between when I filed that, my client did get served some new additional charges. At this time, I'm requesting to withdraw that bond motion.
Okay.
I believe the new charges were served on May 3rd, I believe. If we can keep her set for the 7/8 date, I'm going to get together with Mr. Snell, just see the status on these new charges.
Sure. So you want all of her cases set for July 8th?
Yes.
Okay. And if the state offers Ms. Smith something that she wants to accept before that, you can set it for her hearing.
Correct. And before these new charges, it was a 11/29 offer, so it wasn't like the deal was to get her out or anything like that, but 7/8, we'll keep you set for 7/8, but if I can work out a deal, we can always bring you to court earlier. Okay?
So I'm not going to court on the 20th.
I believe, is that arraignment, Judge, on the new charge on the 5?
You said on the 20th.
That's pretrial.
Oh, for pretrial.
It's July 8th.
July 8th, yes.
Okay. So pretrial and the other cases will,
Fall, okay.
yes.
Yes, Judge.
Okay. So Ms. Smith, go ahead. Removed from today's docket.
Monday.
Monday's docket. Yes, ma'am.
Yes.
Correct.
For these, yes.
Because you've got a new case, and I understand.
Yes, Judge.
Okay. Ms. Smith, I'll see you no later than July 8th.
July 8th, yes.
Correct.
New charges have to file on
This was the Starks that's next.
Thank you.
You need more time? This is the same 6-month offer.
I know.
Mr. Koch, what are we doing?
Do you want to move forward with that, please? Okay, Judge, if you want to sign right there, and today's the 16th. Judge, if we could set my client for the 23rd date next Thursday. This offer will not get a release today, but if I could have another time to talk to her at the jail, and
Okay.
I could wrap it.
What's the offer from the state?
Judge,
Is
for
it
all,
incarceration or?
it's 6-month county jail offer to resolve all her.
And she hasn't gotten that credit yet?
Correct.
Okay. The reason why I asked that, Ms. Starks, is, you know, you're going to be either in jail or here next week anyway, so I want to give you the time to do that. I'll see you a week from today, okay? I can't, Mr. Koch has a good feeling, and I haven't seen these prosecutors pull offers from them, but just know that the court can't force the state to keep an offer open for you, okay? So if the state decides for some reason to withdraw that offer, I can't make them keep it open, okay? But again, I think Mr. Koch probably has a pretty good feel that it will remain open for the next week, so I'll see you next Thursday, okay?
Okay, Ms. Starks, I'll hold on to this. I'll hold on to this. Go ready.
That's all for the 9 o'clock docket. On the 1:30 docket, we have Raven Nunn.
Okay, thank you.
Okay. Your Honor, this is Ms. Raven Nunn, and I was just going over the terms of the plea agreement. I know security is kind of backed up today, but I do think Ms. Nunn needs a chance to read this plea agreement before she agrees to it. So if I could pass her to the end of this 1:30 docket.
Okay.
And I'm going to hand her the plea agreement. And Rachel, I'm taking the staple out. So.
Ms. Nunn, I'll see you later this afternoon, okay?
Okay.
Thank you.
Yeah, I just double checked that. It's not double jeopardy. I wish it was. Okay, I'll see you in a minute.
Also, Raven Nunn is not done. She just got handed a plea agreement. She just needs to read it. They're getting them right now.
Okay, thank you.
Mr. Lyons first. The kittens, the Lyons. Liberty and Lourdes. Do you want to skip it?
Yeah, over.
Okay.
I don't know if he's going to take that plea. Basically, I'm just letting him know this is the current offer, but in case he does come out and is like, oh, I want to take it. Yeah, he should not be on the transfer. Okay. Yeah. Strangely enough, I'm not ready to clean the arms all the way. Yep.
Thank you. Yeah. Told me. Yeah.
Lyons, Moser, Phillips, Richardson, let's go. Lyons, Moser, Phillips, Richardson, and now what?
Mr. Kleins?
Yes, sir. This is Lakevis Lyons, Your Honor.
Good.
We do have receipt of a 2-count information. If I could just have 1 second. Your Honor, I was just explaining to Mr. Lyons, the issue with his case is he's charged with escaping from DJJ custody. And so I have tasked our juvenile attorneys to find out, like, if he accepts the state's offer, does he go back into DJJ custody to finish whatever program he's in? I don't have an answer on that right now. So I will waive the formal reading into a not guilty plea. Once I get an answer, I probably would expect the court's going to see Mr. Lyons before July 8th.
Good.
But I'd hesitate to plead him to something not knowing what may happen to him.
Absolutely.
So, Mr. Lyons.
So, Mr. Lyons, I'll see you back here no later than July 8th, but I have a pretty good feel that Mr. Klein's going to get some information, and I may see you as early as next week or after that.
Okay.
Thank you, sir.
All right, man.
Ronald Phillips is next.
Thank you. Hello, Mr. Hey, good day.
How are you?
Good, how are you?
Yes. It's okay. Your Honor, we're here. This is Mr. Ronald Phillips, 24 CF 669. They did file formal charges in my hands, so we'll be entering not guilty to both counts, wait formal reading, and if we keep him set for the 7-8 docket for the pretrial.
Okay. Mr. Phillips, I'll see you no later than July 8th, okay?
Yes, sir.
Thank you, sir.
Keep this. Yep.
You have a blessed day.
Thank you, sir. You too.
John Richardson?
Hello, Mr. Richardson. Good. How are you, sir?
Good morning. Okay, I did file. Your Honor, this is Mr. Richardson in 24 CF 844. We did receive the formal charges. We'll be entering not guilty to both counts. If we can keep this set for the 7-8 docket for pretrial.
Okay.
Mr. No.
July 8th.
I'm sorry, Judge.
Mr. Richardson, I'll see you no later than July 8th.
We can set you early, of course, if we work out a deal. At this time.
That's the pretrial conference. If Mr. Cox schedules a motion or if the state offers you something you want to accept, then Mr. Cox can move it up on the docket.
But what about past signed probation in Santa Rosa? And, like I talked to the judge and like my lawyer over there, they said like I can get my probation rank concurrent because these charges like similar, like they happen around the same time.
Well, and that may happen in Santa Rosa, but I need to know what's going on with this case. Unless there's an agreement with the state, I don't have anything before me. I march toward trial.
At this time, that offer is not on the table. But if we do reach an offer, we can always set you earlier. But at this time, there's no offer.
From this state attorney.
Correct. At this time, we can't address that, okay? I know, July 8th, but I could always bring you earlier if we get it agreed upon. If not today.
I'm saying like, is it able to come see?
Yeah, absolutely. Well before that date. I'll see you this weekend. It's probably Sunday.
Ricard Rowe is next.
Thank you.
I know. At this time, there's not, it's just gonna be easy. I know that. I'm just gonna say it on the record at this time.
Hey, look into them.
On this one? Yeah.
That's a weird fact pattern.
Okay, yeah, and I went to see him, and I think they're using something. They didn't bring it over, so yeah, it's on my list.
I mean, like, doesn't even make any sense.
Yeah. Because I had trouble sleeping.
I mean, you'll get a deal.
Yeah.
Are they? Okay.
Let me get through these. I know.
Judge, do we have a couple of seconds real quick where I could maybe talk to you?
Sure. Rachel, so how long do you need? So to the state, you want a break?
No, if I could just come up and speak with you real quick.
Yes,
I just
sir.
wanted to let
Come
you
on
know.
up.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his
and that
clients,
conversation
as is
wasn't about
evident
your case,
by this
just so you know.
extraordinary verdict.
Yes, sir.
Judge, this is Mr. Ricari Rowe, 24 CF 804. We did receive the information. We'll be entering not guilty to both counts, waive formal reading, and request that my client be kept on the 7-8 pretrial docket.
Okay. Mr. Rowe, I'll see you back here no later than July 8th. Okay? Thank you.
Okay? Yes, sir.
Thank you. Hello, Mr. Schlegel.
Hey, how you doing?
Good, how are you?
Pretty good. Your Honor, receiving the information, we'll be entering a not guilty, waive formal readings. My client, I did speak with him, and he is accepted into Keaton.
Good.
He also has a Walton County VOP hanging out there, so I'm trying to coordinate, but our main goal is to get my client into the Keaton program.
Super.
So
if you pull off something before July 8th, you'll bring him in.
and I anticipate that.
Good. Mr. Siegel, I'll see you no later than July 8th.
Okay, thank you, sir.
Thank you.
Michael Wagner is next. He has military.
Okay, thank you. Hello, Mr. Wagner.
Hi, Your Honor.
So, Mr. Wagner, do you wish for me to appoint the public defender if you qualify financially?
Yes, sir.
How much money do you make per month?
I'm unemployed.
How long have you been unemployed?
About a year.
Okay.
I've had to file for Social Security disability.
Okay, I do appoint the public defender to represent you.
Okay, thank you, Your Honor.
Mr. McKinney's approaching on your left.
Okay, thank you, Your Honor.
Jason McKinney for Mr. Michael Keith Wagner in 24 CF 856. We would acknowledge the receipt of a two-count information, waive its formal reading, and our plea of not guilty.
Okay.
I'd like to stay on the 7-8 pretrial conference docket. May I have a moment?
Yes, sir.
Is that, nope, that's a different instrument. Thank you, Judge.
Mr. Wagner, I'll see you no later than July 8th. Thank you, sir.
Michael Walker is next. He also has no thing at this time.
Thank you, ma'am.
They're not on the transfer and they're not on my docket.
If you pull up her case and look at the document on the first website, it's blue is at the top. Pull up Teresa's case and then look at the docket and it's got her on there. And no West on there for a while.
Right, yes, ma'am, thank you. Hello, Mr. Walker.
Hello.
Mr. Walker, do you wish for me to appoint the public defender if you qualify financially?
No.
You're going to hire a private attorney?
No, I'd like to proceed without one. And maybe talk to the state's attorney about a possible plea deal.
Well, they don't even have an information filed against you yet. So to the state, can you make an offer before you have an information?
This is it's gonna be DOC, he's gonna score. So
Okay.
it's,
So even if you offered something, it would be to prison,
it will, and he's gonna qualify for PRR, I believe, too, so.
which, Mr. Walker, PRR is prison releasee reoffender. Don't you want me to appoint a public defender to represent you?
I only have petty theft, so I'm sure I don't qualify for that. I don't think
Well-
it's not a qualifiable charge.
Well, they're seeking prison against you.
Right, but that's not qualifiable for PRR, petty theft charge.
Okay, well, and and you're going to represent yourself, Mr. Walker?
Oh, I'm supposed to talk to you?
Talk to me.
Oh, okay.
Okay, so.
Let me talk to you then.
Okay, the state's not making you an offer other than prison.
Okay.
You don't have an attorney.
All right.
Do you want me to appoint an attorney? Or do you intend to
My
hire
question is, what does it mean the information isn't filed?
the charging document, the official charges from the state against you for the petty theft, the charges against you?
It's a mistake?
No, they just haven't, they have a certain period of time that they can file that against you. If they don't within that period of time, then you're supposed to get an ROR bond. But that time period hadn't expired yet. If I appoint an attorney to represent you, that attorney will know all that stuff. So don't you want an attorney?
Well, how long do they have to do that?
I can't give you legal advice.
I mean, is it not about to run out? Because I've been in jail for like 30 days.
You're standing there alone, asking legal questions.
Oh, yeah, I know. I don't know why they didn't appoint me one.
Okay, well, and I will appoint you one if you want one. Do you want an attorney?
Yeah, I guess so, because it sounds
Okay.
like he's got the wrong.
How much money do you make per month?
Pardon? About 2,500.
Okay. Did you
But I
work?
have a lot of bills, and
Okay. Because of that amount, Mr. Walker, I can't appoint you one right this second.
yeah, that's.
They'll give you a financial, okay, now listen to me, okay?
I'm listening.
They will give you a financial affidavit at the jail. Fill that out, load it up with those expenses that you have, okay? Because the clerk may say you don't qualify technically for a public defender because you make too much money. But if they send that back to you, there's a place that you can appeal it to the judge. And we have more latitude than the clerk does. So we can look at it and say, although he makes $2,500, he's got all these bills, there's no way he could afford to hire a private attorney, and we would appoint the public defender, okay?
Okay.
So I'm not appointing them yet. I will see you back here in 1 week. Fill out that financial affidavit before that. Hopefully, when you come back in a week, you'll have an attorney,
Yes.
okay?
Okay.
Thank you, sir.
All right.
Next, I have Butch Miller.
Thank you.
Morning, Judge, or afternoon.
Good afternoon, sir. Good afternoon.
Hey, how you doing? You got that, please? Or do I have it? Your Honor, this is Butch Mosier, and, yeah, 24 CF. $868.
Okay, hold on 1 second. Mr. Nettles, what do you think scheduled for now?
Well, I had two bonds, Cerise Loomis and Elijah White. And I got the, when I pulled them up on the clerk website, they're both showing on the docket they have on the website, but they're saying that they're not on the docket, so.
Correct, you filed notices of hearings for bond motions on the felony pleading docket, and like we've had this issue before, the only thing that can be said on felony pleading docket is a felony pleading, because they will not populate on the docket when we send it out.
Okay.
I didn't select that date, that's the date they gave me when I requested the date for the bond hearing on Mr. White.
We would not give you a PM docket. All PM docket hearings are scheduled through months.
Well, I'm not set, I don't know what you're, but
So
I understand what you're claiming, but I didn't get this date out of thin air.
She's not saying anything about the date, she's saying about the time. She
I
would, they would
understand
never
that.
schedule
I had to take the
it.
time from the clerk's office.
So you're ready to argue your motions? Is that what you're telling me?
Well, I'm here for bond motions, Judge, it's not really,
Okay.
and I don't
To
think
the,
the transport, so I don't think
okay. So
Apparently it's moved.
what about if we do them on Monday afternoon?
We have 137 on Monday, Scott.
That's not, okay. So then a week from today, Thursday, in the morning?
It's a jury review docket, so it's up to you.
In the afternoon then. Okay, so let's do it for May 23rd at 2:30,
May 23rd, 2:30.
a week from today. Okay, thank you, sir.
Mr. Snell just indicated to me that he wants to work something out on white, perhaps we can take care of that then.
And you, if you work something out, bring him in on Monday. Just let us know. Let's get it scheduled. If it's going to be a plea, I'll take it anytime I've got a document.
I think it's time to talk to Mr. White about it.
Understand.
Okay.
Thank you, Mr. Nettle. Yes, sir. Okay.
Your Honor, this is Mr. Mosier in 24 CF 868. Yes. We good? Okay. There is a two-count information, Your Honor. Mr. Mosier is going to be entering a no contest plea to that information as charged. The agreed-upon disposition on count one is that Mr. Mosier will be placed on 2 years of probation. He would perform 24 hours of community service, submit to a substance abuse evaluation and any recommended follow-up treatment, be assessed $615 in court costs, $150 in public defender fees. Count two is a misdemeanor. The agreed-upon disposition will be sentenced to time served. It's not written on the plea agreement, but I talked with Mr. Gomez, and given the fact that Mr. Mosier is pleading at arraignment, the state would agree to automatically early terminate probation at 18 months if there are no violations and everything's been taken care of.
Okay.
May I approach?
And then there's $40 per month cost of supervision, right?
That's correct, Your Honor.
Good.
May I approach?
Yes, sir. Mr. Mosier, if you raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Okay. I do accept your plea. You're adjudicated guilty. You're sentenced to 2 years probation in count one, time served on count two. You'll need to perform 24 hours of community service work, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. You'll need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision. Your supervision will automatically terminate at the 18-month mark if you haven't committed any new law violations and have completed all the terms of your supervision. Okay? Thank you, sir.
That's for you. All right, good luck.
Lelania Whitson is next. Mr. McKinney.
Right.
Judge, this is Miss Whitson before the court, and I hesitate because I can't say her first name. And she's here in 24 CF 825. And I acknowledge the receipt of a 3-count information, waive its formal reading, enter a plea of not guilty. The pretrial date is scheduled for July 8th at 9 a.m. I have scheduled a bond hearing for Ms. Whitson, and I believe I noticed that, Madam Clerk, for 5/23 next week at 9 a.m. If that needs to be in the afternoon, I can re-notice it. But it would be a very quick bond hearing with Ms.
Okay,
Whitson.
we can keep it in the morning.
So the court would see Ms. Whitson next week related
Good.
to the bond.
Ms. Whitson, I'll see you a week from today, and then your underlying case is continued until July 8th, okay? Thank you, ma'am. I'll see you next week.
That'll be next Thursday morning.
Jonathan Yates is next, Judge. He doesn't have an attorney, but Mr. father's on the rest of this case that we do.
Okay, thank you.
There's also no information filed.
Okay, thank you. Hello, Mr. Gates.
Hello, sir.
Hold on one second, let me find you on my docket.
It's the last one.
Yates, got it. So, Mr. Yates, do you wish for me to appoint the public defender if you qualify financially?
I have James Heath for this. I guess he hasn't filed the paperwork for it yet or something.
Okay, he hasn't, and the state hasn't filed an information against you yet.
Okay.
So that means I'll see you back here a week from today.
Okay.
So get Mr. Heath to get in touch with the state. Maybe they can work something out before Thursday.
Okay.
Thank you, sir. Okay. Folks that are in the gallery, anybody ready to go on the 1:30 docket?
Russell Thorne. DeAndre Tarver.
Okay, let's see about the pro se's. Raymond Wagnon? Nope. Did we do? Okay. LeBryant Warnick? Nope. I think that was all of the pro se's. If you're a defendant that's here for arraignments at 1:30, if you'll stand up, please, if you want to, just one at a time, if you want to come to the lectern and we'll figure out.
If you're here for arraignments at 1:30, if you'll come up here and form a line and then go to the left.
That'd be great. Okay. Come on up. You don't want to be first. Okay. Come on up. Yes, ma'am. What's your last name?
Martin. Martin.
Martin. Thanks, Miss Martin.
Martin. Yes, sir.
Your Honor, this is case number 24 CF 835. I spoke with Ms. Martin before court today. She was here early, so thank you for that.
Right.
There was allegedly some documents that were dropped off to our office that would cause us to dismiss this case. I tried to get my legal assistant to look for those. At the time, we can't find it, so I've given my contact information to Ms. Martin. Hopefully she can email me sometime today or tomorrow, and if she does and I review the documents, I will no-process it. I would like to set this case for
a week
next
from
Thursday.
today?
Yes, a week from today.
Good.
Just to kind of review back on. If we can't have it on the plea day docket, I don't know if that's allowed.
It'll just be reflected as a plea date, not like a status.
Okay, perfect. Yeah, I would just like that, and the hope is that once she gets me that, I'll review the documents and file a no process. I won't even get to them.
Okay. So that means I'll see you back here a week from today at 9 o'clock, unless the state, when he says null process, that means it dismisses it.
Yes, sir.
Okay, in that event, you won't have a case that you need to be here.
Yes, sir.
Thank you,
Well,
ma'am.
okay, so instead of 1:30, 9.
1:30, okay, at right, because it's an arraignment. At 1:30 on...
Next Thursday.
Yes, ma'am,
Okay,
May 23rd.
May 23rd. Thank
Yes,
you.
ma'am, thank you. Okay, yes, ma'am, come on up. What's your name?
I'm Allison Rajanti.
Okay. Deshanti with a D?
No, it's with an R.
An R.
Number
Rashanti.
17 on my docket.
Okay, thank you. Good, yes, ma'am. It's 24 CF 839. Ms. Rashanti, do you wish for me to appoint the public defender? Do you want an attorney, Ms. Rashanti?
I don't want an attorney. I would like a public defender, please.
Okay. How much money do you make per month?
not enough, but enough to be comfortable and live with my family right
Okay.
now.
She just lost her job. She was in the
I'm
hospital.
sorry, yeah.
Okay.
So she has no job and no insurance.
Understand, and just for the record, what's your name?
I'm sorry, I'm Connie Rajanti,
Okay.
and I'm her mother.
Yes, ma'am. Ms. Rashanti, how long have you just lost your job? How much were you average making per month before you lost your job?
I don't remember. I thought this day was just for me to ask for a public defender.
And that's, I'm trying to see if you qualify
Sorry.
financially for that.
Yes,
Did
sir.
you
I
make
don't
more?
have money for that. I'm sorry. I don't make enough money for an attorney at all.
Okay. Did you make less than $2,000 a month?
No, I made enough for that.
Made more than $2,000 a month?
Mm-hmm. But not always.
Okay. To your mom, did she average making more than $2,000 a month?
Truthfully, I didn't handle her
Finances?
but I know she doesn't make a lot of money in the
Okay.
job that she
Your
was
Honor, I
in.
think in this scenario, I think the best case would be to appoint a
I-
public defender and.
I do too. Mr. Rashanti, I am appointing the public defender to represent you. This is Mr. Koch, okay? And now, is there a guardianship set up or anything formal, Ms. Rashanti, between you and your daughter?
No,
This
I
is
just,
not,
I received a letter as well to be here today with her.
Okay. Okay. Well, you can remain standing there for today, okay? Till we figure out. Okay.
Her,
Oh, okay.
are you sure?
her permanent address is my permanent,
Understand. If the only reason why you got notice was because you posted the bond,
I did.
you really don't have standing to be on this side of the bar. You always hear about past the bar. The bar is that rail between the gallery and the well. And so if you're not an attorney or a party, you can't be past that. So, Mr. Koch, I'm sure we'll be in touch with you and talking to you, but if you just don't mind stepping back behind the bar.
I don't mind, Your Honor.
This is what I need to sign?
No.
No, ma'am, you don't need to sign anything yet, okay? So Mr. Koch is your attorney, okay?
Okay, thank you.
And Judge, just to get up to speed, and I apologize, I was outside.
What?
Has information been filed yet in this case? Okay. So our next court date is on 7/8.
It has been filed.
Okay,
Good.
thank you. So I'm going to hand my new client my card.
Thank you.
Okay.
And please contact that number, you can make an appointment, so we can discuss
will.
more of the case.
Ms. Rashanti, I'll see you on July 8th, okay? But make an appointment with Mr. Koch,
Thank
okay?
you.
Yes, ma'am. Absolutely.
Appreciate you.
Yes, ma'am.
very
Thank you, ma'am. Yes, sir. What's your name?
Herman Phillips.
Mr. Phillips. Good. Mr. Koch, you represent Mr. Phillips. It's number 12 on my docket.
Excuse me, right there. Can I see this? They did file formal charges. Your Honor, receiving the information, will be entering a not guilty to all 3 counts, waive formal reading. Request that this be kept on that 7/8 pretrial. And I'm going to hand my client my card. Excuse me, schedule an appointment.
Mr. Phillips, I'll see you back here on July 8th
Okay,
at
thank you.
9. Thank you.
Excellent.
Yes, sir. What's your name?
Dakota Stevens.
Stevens.
What's up? I'm just good for you.
Yes, sir.
Good day so far?
Yes.
Good to you.
Your Honor, Mr. Stevens has received formal charges, will be entering not guilty, requested be kept on that 7/8 pretrial. And I know you've been in contact with my office already, but
Yeah.
I'm just going to give you another card.
Appreciate
Just
it.
to make sure, call, schedule an appointment.
Okay, sweet. Thank you.
July 8th at 9 o'clock. I'll see you then.
Yes, sir.
Thank you, sir.
I'll see you then. Yes, ma'am.
Okay.
Yes, sir. Come on up. What's your name? I'm sorry?
Aiden Ponto.
Ponto?
Yep.
Good, thanks, Mr. Ponto. '24 CF 655. Does the state have an offer for Mr. Ponto?
Hold on, Your Honor.
Mr. Ponto, I see what the charges are. If the state has an offer that you may want to accept, then we'll talk about waiving a jury trial, waiving an attorney.
Okay.
If you have any doubts, I'd sure want to get an attorney, okay? Let's see.
Your Honor, at this time, it would be an adjudication withheld, 18 months of standard probation, $615 in court costs, a substance abuse evaluation within 30 days, and getting recommended treatment within 60 days, and 24 hours of community service work.
Okay. Mr. Ponto, have you ever been on probation before?
No, sir.
Okay. Do you wish for me to appoint the public defender if you qualify financially? Do you want an attorney?
Yes, sir.
Okay. How much money do you make per month?
Around 4,000.
Okay. You're not going to qualify for a public defender?
Okay.
So I can't appoint the public defender to represent you. Every attorney in the courtroom says you need an attorney. I mean, we're taught in law school, if we represent ourselves as an attorney, we have a fool for a client. So that's how much we think you need an attorney. So I will enter a not guilty plea for you. The reason why you're here are the charges of drug possession without a prescription and possession of paraphernalia, entering a denial, setting your case for July 8th at 9 o'clock. I'd strongly recommend that you talk to an attorney. You can tell them that the state's offered you 18 months probation, and that's what your offer is. That attorney may say, take it and run. You don't need me, or that attorney may say, you need me, and then you can figure out what you want to do.
Yes.
Okay? So July 8th, 9 o'clock here.
Okay. Yes,
Thank you, sir. Yes, sir.
Morris.
Norris? Morris. Thanks, Mr. Morris.
M-O-R-S-A.
Good, thank you.
Your Honor, this is Johnny Morrison, 24 CF 869. There's no information filed, and I got Mr. Morris's phone number and basically told him, I think the court's probably going to put this on for next Thursday. I'll waive his appearance if the court will allow me to. I'll enter not guilty to written not guilty plea as soon as I see the information filed.
Wait,
Okay.
hold on. Scott, this is the one that I emailed you on about, I had offered the adjudication to get a little credit for time served on the POP. I'm not going to file an information, it would technically be a misdemeanor. We don't have enough to test the substance on count one, so I was trying to get it resolved today in lieu of filing. That's the only reason why I wasn't filing, Your Honor, because I knew that it would cause like a huge issue with transferring it down. I'd rather just play it out today if we can.
Okay,
I'm going to talk to him as well.
good. Mr. Morris, I'll see you later this afternoon.
Thanks for
Yeah.
Okay. Yes, sir. What's your name?
Brian Warnick.
Thanks, Mr. Ward. Is there any offer from the state to Mr. Warnick?
You get probation offers and restitution.
Mr. Warnick, have you ever been on probation before?
Yes.
Okay. So how many months probation are you offering?
Right now, it'd be 24.
Okay. Mr. Warnick, do you want me to appoint a public defender if you qualify financially?
I'm gonna get an attorney.
Okay. So, Mr. Warnick, they're handing you the information, the charging document against you, charging you with criminal mischief, over $1,000. I'm entering a denial for you on the charge, and I'll see you back here on July 8th at 9 o'clock. If you're going to hire an attorney, do it sooner than later. If you decide that you're not going to hire an attorney and you want a public defender, fill out the financial affidavit and turn it into the clerk. Okay? So July 8th, 9 o'clock.
Okay, and I don't live in the state, so.
Okay? Need to get an attorney sooner than later.
All right.
Okay? Thank you, sir. Yes, ma'am?
Whitney McDonough?
McDonough?
Yes.
Thank you, Ms. McDonough.
Wait.
Fallon.
Okay, so your attorney's already filed a denial for you, so then I'll see you back here on no later than July 8th at 9 o'clock. If the state offers you something that you want to accept before July 8th, talk to Ms. Jakewood about that. She can set it for a hearing on July 8th. We'll have over 300 people here. So if
Okay.
you want to avoid all those folks, and the state offers you something that you think is in your best interest, talk to Ms. Jakewood.
Okay, great, thank you.
Thank you, ma'am. Yes, sir.
Good afternoon. I'm Brandon Preston.
Thank you. Preston?
Preston, Preston.
Good. Thanks, Mr. Preston. Good. 24 CF 705. Mr. Preston, do you wish for me to appoint the public defender if you qualify financially?
I'm sure, but I will consult with an attorney outside of the public defender's office.
Okay. It'll cost you $150 if I appoint the public defender, so if you intend to hire a private attorney, I wouldn't do it
Oh,
right
yeah,
now.
it's no need to.
Okay, so you were handed the information for larceny over $2,000 and forgery.
Okay.
I'm entering a denial for
For the
you.
record, it's larceny over $20,000.
Correct.
Thank you.
Just want to make sure, yeah. This only one we don't have an offer right now, Your Honor.
Good, okay, thank you.
All right.
Entering a denial for you, setting your case for July 8th at 9 o'clock. Hire an attorney sooner than later. If you decide that you're not going to hire a private attorney, fill out a financial affidavit with the clerk, okay?
All right.
Thank you, sir. Mr. McKinney?
Judge, this is DeAndre Tarver before the court in 24 CF 769. I'm providing my contact information on the business card. At this point, we would acknowledge the receipt of a one-count information, waive its formal reading, enter a plea of not guilty. This is scheduled for July 8th for pretrial.
Okay. Mr. Tarver, I'll see you on July 8th, okay?
Yes, sir.
Thank you, sir. Yes, sir. Come on down.
Jerome Smith.
Hello, Mr. Smith.
How you doing? Smith.
Smith, okay?
Madam Clerk, did you by chance get the information
Smith Lee.
that was filed? We filed it this morning. I apologize for that. I just found out that I'm going to be taking over the case as there was a conflict with ASACL, and I found out that this morning, but I did immediately file an information once I got it.
Okay, I don't see it on the docket.
I had it on mine.
Oh, Mr. Smedley?
Yes.
Got it. I'm sorry, Mr. Smedley. 24 CF 673. So there's no information filed? Or?
There was this morning, my printer's not working, so I can't.
Great. Can you get someone to bring a copy down?
There's nobody in our office.
Okay. Mr. Smedley, you got a couple different options. One is you can come back in a week and we can give you that paperwork. Or two is we'll take a break as soon as we finish with the folks here.
I can come back in a week.
And before 2:30, and they can hand it to you then.
I can come back in a week.
Okay, I'll see you in 1 week at 1:30. Okay, thank you, sir. Yes, ma'am.
Lacey Taylor.
Thanks, Ms. Taylor. '24 CF 694. Does the state have an offer for Ms. Taylor? It's number 31 on my docket.
It'd be 36 months of probation with all of the...
Okay, thank you. Ms. Taylor, do you wish for me to appoint the public defender?
Yes, sir.
How much money do you make per month? You have to say it verbally.
Oh, none, I'm sorry.
Okay. How long have you been unemployed?
For at least a year right now.
I do appoint the public defender to represent you. Mr. Koch is approaching on your right.
Ms. Taylor, oh, sorry about that.
Sorry, hi.
Mr. McKinney's on your left.
Jason McKinney for Ms. Taylor. We would acknowledge the receipt of a one-count information, waive its formal reading, enter a plea of not guilty. This is scheduled for the July 8th pretrial. We'd like to leave it on that date.
Okay. Ms. Taylor, I'll see you back here on July 8th at 9 o'clock.
Did I hear correct that the state's offer is 3 years probation?
Correct. Okay, thank you, ma'am. Yes, sir. What's your name?
Devontae Tibbs.
I'm sorry, your last name is?
Tibbs. T-I-B-B-S, Tibbs.
Tibbs, okay. The acoustics aren't the best in here. Good, Mr. Tibbs. 24 CF 819. Mr. Tibbs, do you wish for me to appoint the public defender if you qualify financially?
No, sir.
Okay, you going to hire a private attorney? Or are you going to represent yourself? Do you want to hear if the state's got an offer for you? Okay. State have an offer for Mr. Tibbs?
It's probation,
Okay, how many months?
18.
Okay. Mr. Tibbs, have you ever been on probation before?
A while ago.
Okay.
2 years ago.
Okay, so you know what you'd be getting into. The state's offering you that. If you want to accept it, you'd be waiving your right to a trial by jury. You'd be waiving your right to an attorney. If you don't want to accept that today, then I will set your case for July 8th at 9 o'clock. You can then decide whether you want to seek a public defender or hire a private attorney or accept the state's offer.
So they offering probation over a license plate tag?
Yes, sir. Right now, they're offering 18 months probation. An attorney may be able to talk them into something else.
No, I don't accept that offer.
Okay. So I do enter a denial for you. I'll see you back here on July 8th at 9 o'clock. If you're going to hire a private attorney, do it sooner than later, okay?
Okay.
Thank you, sir. Yes, sir. What's your name?
Raymond Wagner.
Thanks, Mr. Wagner. 24 CF 713. Mr. Wagner, do you wish for me to appoint the public defender?
Sir, I'm going to hire a
Private attorney?
yes, sir.
Okay. You've been handed the information, the charging document for aggravated battery and aggravated assault with a deadly weapon without intent to kill. I'm going to enter a denial for you, and I'll see you back here on July 8th at 9 o'clock. Okay? Thank you, sir.
Have a good day.
Yes, sir. You too. Yes, sir. Morris? Thanks, Mr. Morris.
Your Honor, after speaking with Mr. Morse, he does want to accept the state's offer. And that offer would be to, if Mr. Morse wanted to enter a plea to one count of possession of paraphernalia, the agreed upon sentence would be that Mr. Morse would be sentenced to time served, be assessed the misdemeanor court costs, 100, actually, given the fact I've done pretty much nothing in this case, I would ask if the court would allow me to step back and not assess him a $100 public defender fee. He is on a fixed income, and his intent was going to be to ask the court to give him 9 months to pay the court costs.
Okay, and then count one as no prost?
No cross, Your Honor. I don't even think we filed on it for the specific reason of we knew that it would just be a misdemeanor plea offer, so we would no cross that, Your Honor.
Okay. So, Mr. Morris, if you wish to accept that, you're waiving your right to a trial by jury. You're also technically waiving your right to an attorney. Do you understand that? You have to say it verbally.
I understand.
Okay. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You can put your hand down. So, Mr. Morris, you understand that you're waiving your right to a trial by jury, waiving an attorney. What's the adjudication for Mr. Morris?
Adjudication of guilt, Your Honor, credit for time served.
Okay.
It's just a misdemeanor.
Misdemeanor. Mr. Morris, you understand that you'd be adjudicated guilty of a misdemeanor?
Mhm.
That's yes?
Yes.
Okay. Any questions for me or the state?
No.
Okay. Mr. Morris, I do accept your plea. You're adjudicated guilty of the misdemeanor. You're sentenced to credit for time served. You will need to pay the court costs. If you fail to pay those within 9 months from today, then they will go to a civil lien or judgment.
How much is the cost? Okay.
Okay? Thank you, sir. Good luck to you.
Then we're going to recall Raven and then.
Okay, thank you. So I thought, okay, this meeting ends in 40 minutes. So, uh-oh.
Any questions? What? Early term, but you gotta pay this restitution first. Okay. You good with that? All right, go ahead and sign and date it. This is Miss Raven Nunn, Your Honor. She has reached an agreement to resolve this particular case. At this time, Miss Nunn will acknowledge receipt of a 2-count information. She's going to be entering a no contest plea as charged on those. And just for the record, I did confirm one of the concerns that Miss Nunn had was whether or not these counts would be double jeopardy. I did research. It is not double jeopardy to be charged with grand theft and other forged instrument. So she's going to be pleading to both counts. She's going to be placed on 2 years of probation. Special condition is that she will pay $800 in restitution to Simply Elegant. She's also to have no contact, no trespassing at Simply Elegant. I do not know where she's going. And it's not on the plea agreement, but the state would agree to automatically early terminate supervision at 18 months, provided that all the special conditions of supervision have been accomplished at that point. She would be assessed $615 in court costs, $150 in public defender fees. She's previously been adjudicated of a felony.
Okay.
May I approach?
Yes, sir. And $40 per month, correct?
Yes, sir.
Thank you. Ms. Nunn, if you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Nunn, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Nunn, I do accept your plea. You're adjudicated guilty. You're sentenced to 2 years probation. And that's to run concurrently, run at the same time. You'll need to pay the $800 in restitution. No trespassing at Simply Elegant. You'll need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision. Your supervision will automatically terminate at 18 months if you've successfully completed all the terms of that supervision at that time and haven't committed any new law violations. Thank you, ma'am. Good luck to you.
Good luck.
Judge, I think there's a couple on the plea docket that's going up the plea.
Okay? Yes, ma'am.
Herbert Schmidt.
Hello, Mr. Schmidt.
Yes, judges, we'll be entering a admission. If I could just have a moment to get a signature.
Yes, sir.
Carol. Right here, 516. Judge, thank you. This is Mr. Schmidt in 2022 CF 416. This will be an admission, Your Honor. This will be 90 days, Okaloosa County Jail. And I want to make it clear that my client will not receive any credit time from up to today. So he will be serving a fresh new 90 days. And I also put in the plea form, all prior credit time is waived. My client will be reinstated to sex offender probation with all the original terms, all original conditions, and all original costs. GPS to be reattached before being released from the Okaloosa County Jail. There's the $100 cost of prosecution for the VOP and the $150 for defense costs. I also notated on the form that this is a downward departure based on a legitimate, uncoerced plea bargain. And if I could just have a brief moment.
And the
Judge.
adjudication is guilt?
Yes, Judge.
Yes.
I
Thank you.
apologize. Your Honor, my client does have a question about the fees, and I just want to note that for this violation of probation, you're responsible for the $100 cost of prosecution and the $150 defense costs. Also in this plea, any outstanding fees from when my client pled out, my client is responsible for it. I did tell him that we're not adding any more fees. If at the time of that plea back in 2023, if it was waived at that time, it's still waived. But if he's responsible for that original plea, there's any costs or conditions. Does that satisfy that question?
As long as the fees are waived, because they were waived that back then.
Okay. And just to answer that on the record, any fees that were waived, of course, they're still waived. We're not imposing any more.
Right.
Does that satisfy your question?
I guess.
Mr. Schmidt, we'll talk about it, okay?
Okay.
Okay.
If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down. So, Mr. Schmidt, let's talk about the money that's concerning you. So it would be reinstating your prior sex offender probation. Whatever all those terms are, I'm not touching those at all. None. I'm not increasing, decreasing, changing them at all, not waiving everything that you had originally. That contract is what's still in place. The only changes I would be making if you accept the plea is you'd spend the next 90 days in the Okaloosa County Jail, starting from today. You'd have $100 cost of prosecution, $150 public defender's fee, and they wouldn't release you from jail until there's a GPS monitor, and that's it. So is that what you wish to do?
Yes, Your Honor.
Okay, any questions for me?
Yes, all the original fees that I had on the paperwork that he showed me yesterday, those were supposed to have been waived back then because I only make about almost $800 a month.
Okay.
And then you had waived all those fees before.
Okay. Mr. Koch, you're going to check the record and see whatever that original deal was, Mr. Schmidt, I'll honor it, okay? Mr. Koch will look into that, and if he thinks that some way probation or somebody isn't honoring what I sentenced you to, then he'll set it for a rehearing if Mr. McKinney doesn't raise it right now and clarify it. Sure. Gotcha. Thank you. Mr. Schmidt, I'm eavesdropping. I can't waive court costs. I don't have that ability to do that. Talking to Madam Clerk, she said that I waive cost of supervision. I can waive that, and I did waive that, and that continues. But I can't waive court costs. I've never waived court costs. I don't think I have the legal authority to do that. Okay?
Okay.
So you're sentenced in according to what I just stated. Thank you, sir.
All right.
Your Honor, my approach is a score sheet.
Yes,
There's
sir.
none, and I've consulted it with Mr. Klein, and he's stipulated.
That's
correct, Your Honor.
Thank you. Mr. Gomez, are you going to be hearing score sheet in your dreams and your nightmares?
Most likely, yes.
Yes, sir. Good, thank you. Good afternoon, sir. How are you?
It's too early to tell.
Yes, sir. Okay. 1 second. Okay, wait a minute, I'm sorry. Your last name is
Sawyer.
Sawyer.
Like
Thanks,
Tom
Mr.
Sawyer and Huckleberry Finn?
Yes, sir, absolutely. Got it, number 9. I just skipped your paperwork. Because I don't, here we go. It's stuck to another sheet. Got it, Mr. Sawyer. So you filed a motion for ineffective assistance of counsel, and basically made a statement that he doesn't have your best interest at heart. Do you still wish for me to discharge him and appoint another attorney for you?
Yes, sir.
Okay, if you'll raise your, I'm going to get some testimony from you. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Okay, you can put your hand down. So here's what I have to find for you to prevail, for you to win. I have to find that Mr. Koch provided ineffective assistance of counsel, okay? So tell me what facts you believe support that.
All right, I guess I'll start from the most recent.
Or if you, let me interrupt you, or if you think he has a conflict, you say, he doesn't have my best interest at heart. If you're saying he doesn't have my best interest at heart because he knows the victim or, something like that, tell me that too.
Well, Judge, I had wrote this for you last night. Is
Okay?
it okay?
Do you want to read it on the record? Or do you want to just file it and I'll read it?
I mean, I could read it, but if I wrote it to you.
Well, it's going to be entered into, there can't be an ex parte communication, a one-party communication. Whatever you tell me, I've got to share with the state. So either you read it or we'll hand it to the state and let them read it and then I'll read it.
So
But it can't be
I never
confidential
really-
between you and me.
I never did this before, so what would be my best thing? Finish this hearing between the ineffective counsel and then we give this to the state?
I need whatever evidence, whatever facts you believe show that Mr. Koch is rendering ineffective assistance of counsel. I've got to find that for you to win today.
Yes, sir. All right, well, I will start when I first took probation.
Okay?
All right, I am an addict. I have a problem. I've been shooting up heroin for like the last 8 years. And
Yes,
I
sir.
stressed that to Mr. Thomas upon the week before I took probation. I said I got accepted to the Hope House, ECLC, Keaton. Well, can you please, the only way I can get in there is if you sentence me there. He said, all right, we'll take care of that. So I come to court, and he says, you got 2 years of probation. Now, I would assign 10 years of probation just to get out there and do another shot. I have a problem.
Yes,
all
sir.
right? And so I took probation, not knowing, really thinking about the stipulations because I shoot up heroin. I need help.
Yes, sir.
Okay? Now, fast forward till now.
Good.
I've been in jail for going on 3 to 4 months. I've seen him once. And the only person that I have to help me justify what I'm being, I admit that I am totally guilty of my actions, but I'm not guilty for the charges I am charged with. That is totally wrong. And I just feel like I haven't seen him but once, and every time I come to the podium, he says, don't say nothing, I'll come see you, but he never comes see me. Now, I understand this is a waiting process, and the state wants a conviction or something, I don't know, but I got a 6-year-old daughter I'm trying to get back to.
Yes, sir.
I appreciate being in jail. It got me cleaned. I really appreciate it.
Yes, sir.
But I still feel like I need help. And I got accepted in the drug court. I would love to read this, if you don't mind.
So other than Mr. Koch, it sounds like that your argument is that you've only seen him one time in 3 months, and because of that, he's rendering ineffective assistance.
Yes, and because I'm being charged with crazy charges.
Yes, sir.
They offer me DLC time.
Any other facts you want to tell me about him rendering ineffective
Okay,
assistance?
so I only have one person out there that's reached out to him multiple times and only got to his assistant. I think her name's Katie or something, trying to give proof to defend me on the charges that I'm charged with.
Okay.
Because I do have a medical marijuana card, but
Okay.
I'm charged with not having it. That's a felony.
Okay.
And it's just a lot of stuff that's going on that I shouldn't be charged with these charges, anything I trespassed and had a simple possession. But that's the only way that I would be guilty, you know what I mean? I didn't burglarize nothing.
Okay. Okay. Mr. Koch?
Yes,
If
Judge.
you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Thank you, sir. Mr. Koch, tell me why you are not rendering ineffective assistance based upon the allegations and the testimony of your client.
Yes, Your Honor. I'd like to first address the new charges. My client was arrested on March 13th, 2024. The next date for first appearance to the Public Defender's Office was appointed. So 3/14, we were appointed. I'm not even addressing time to open a file, but I saw Mr. Sawyer on April 2nd, so it puts it about 18 days later after he was arrested. I did address that the 23 CF 2432 he was violated on because of these new pending charges. And at that time, I saw him on April 2nd. I told him no information has been filed yet, so we'll have to go through arraignment. About on 4/13 is when Mr. Sawyer sent the motion for ineffective counsel. So from when I saw him on April 2nd, 4/13, at that point, I wanted to wait for us to have this hearing. Of course, discussions with my client stopped when he writes to this court to address this issue. So I saw my client, I just say 18 days after we got appointed. Once he sent correspondence to this court wishing to get a new attorney and I was ineffective, I ceased talks.
Understand. Okay.
And if I could just address the 23 CF 2432, I conveyed the offer that was given by the state attorney's office at that time for the probation offer. Of course, the option of trial is always an option, but my client wanted to take that offer at that time. So we entered that plea on December 14th.
I understand. Okay. Mr. Sawyer. I take what you told me about your addiction. I had someone that was being sentenced a couple months ago that was an addict, and he was homeless, and he said, we will do whatever it takes to get the next fix. Made a big impression on me, especially being homeless and having camps next to other addicts and being concerned about what they may do to you. So when you say that, when you say, I will do anything to get out of jail, so I took the 2 years probation, a lot of validity there. So I understand that, I believe you. But the only thing that you've alleged as far as ineffective assistance is Mr. Koch not coming to see you. And once you filed this motion, ineffective assistance of counsel, it was docketed on April 18th. It was dated April 13th. It took a while for it to be filed with the clerk. Then the attorney stopped communicating with you because they need this ruled upon before they can represent you and keep going on your representation. So there aren't any real facts that get any traction with the court because he was appointed on the 13th. You filed this motion on the 13th, a month later. He saw you in between that. So I do not find that he's rendering ineffective assistance of counsel. I do have some concerns from my perspective that this was filed on April 18th and now it is a month later. as soon as I get one of these, I read them. If it is something similar to this, I say set it for a hearing, so I'll make sure I'm more vigilant. I'm sorry it took a month for it to get, from the time the clerk filed it, to get here, because your attorney's not doing anything on your case for that month. But respectfully, your motion's denied, so Mr. Koch continues to represent you. Mr. Koch.
Yes, Judge.
So is Mr. Sawyer's case set for July 8th?
Your Honor, I believe we haven't addressed it yet because I believe we wanted to have this hearing
Okay,
today.
good. Yes, sir.
I would like to set all three cases, the one VOP and the two new laws, if we can, for that July 8th pretrial date.
Okay. So, Mr. Sawyer, I'll see you on July 8th. Thank you, sir.
Judge, have Jimmy News present in the courtroom.
Okay, please. Yes, sir.
9 and the 1:30 docket.
9 and the 1:30 docket. Okay. Thank you, ma'am.
Keep your hands on the response.
And how do you spell your last name?
M-O-G.
Good, thank you.
I have number 7 on the pleaded docket, Your Honor.
I'm sorry?
Number 7 on the pleaded docket.
Yes, sir, thank you. 24 CF 794 is that case. Mr. Moog?
Yes, sir.
Do you wish for me to appoint the public defender if you qualify financially?
Yes, sir, please.
How much money do you make per month?
Right now, nothing.
How long have you been unemployed?
Quite some time.
How long?
Couple years.
Okay, I do appoint the public defender.
Thank you.
Mr. Kleins is on your right.
Okay,
Yes, sir.
Your Honor, there is a 3-count information. We will waive the formal reading, enter a not guilty plea. Ask that this remains set on July 8th.
Yes, sir.
I know that there was a VOP case this morning. I don't have the case number. If the court would,
I can look that up.
23 CF 285.
if the court would allow me to enter a denial on that and ask that both cases be set on the July 8th.
Yes, sir. That's granted.
Thank you.
Thank you. Mr. Moog, I'll see you on July 8th at 9 o'clock.
Thank you.
Thank you, sir.
Can I write that number down here?
What's that?
Can you write that number down, please? 347. 347-4759. I just got a phone yesterday and I can't get to work.
Mr. Smiley,
You can reach me.
he's on the 2:30 or 1:30?
Okay, but I'll contact you for the number up and down.
Mr. Smiley, come on up.
Yes, sir. My apologies for the court. I was in 3A.
Oh, okay.
I was in the wrong court.
Yes, sir. Well, good. I'm glad you made it down.
Yes, sir.
Mr. Smiley's case is 24 CF 693. Mr. Smiley, do you wish for me to appoint the public defender if you qualify financially?
If I do, yeah.
Okay. How much money do you make per month?
About $2,200.
Okay. Really close, but I can't say you qualify verbally. What I'd suggest you do is before you leave, fill out a financial affidavit and you got one? Good. You already filled it out? Good. Please, if you'll hand it to Rachel. Thank you, ma'am. Okay. Mr. Smiley, did you post the $2,000 in cash?
No, my father did.
Okay. And then the $18,000 you have in debt?
Car payment, credit cards.
Okay. Okay. Mr. Smiley, I do appoint the public defender to represent you.
I'm sorry.
Mr. Koch.
Thanks.
Mr. Koch is approaching. He usually likes to stand on your right, so that's where he is.
Can I see this? Okay. Your Honor?
Yes, sir.
We have the information in front of us, 3 counts, be entered not guilty. Waive formal reading. If we, 1 second. It's okay. If we keep this set for July 8th for the pretrial and provide my client with my card, just please call that number, we can schedule an appointment, then we can address the facts of the case.
Mr. Smiley, I'll see you back here on July 8th at 9 o'clock. You've lost weight, Mr. Smiley.
Yeah, well,
Thank you, sir. Thanks for dressing up.
thank you, sir.
Yes, sir.
Take that with you.
All right.
Okay.
Fugitive for justice on 130.
Okay, thank you. Quinlan, thank you. Mr. Quinlan, come on up to the lectern.
Your Honor, apologies for not being here.
Well, I'm just glad you made it.
Yes, sir, absolutely.
Okay, hold on one second. Mr. Quinlan, you're charged with a fugitive from justice.
Yes, sir.
To the state, still an active case against Mr. Quinlan, I take it?
Is he, from what I understand, did they, California offer you, they gave you a bond and you bonded out? Signature bond, and you have a court date?
I do, yes, sir. I have that documentation of that, and I have representation in California.
Okay.
Yes, sir, and I have.
So what do you want to do?
Then,
You dismiss it?
yes, sir.
Okay. Mr. Quinlan, your case is dismissed.
Thank you.
Thank you,
And
sir.
I remember that day, and you said, Mr. Quinlan, you better take care of this in
Good.
California, and
Yes, sir.
I am all over it.
Excellent.
Yes, sir.
Good.
Yes, sir.
Thank you,
Yeah.
sir.
Thank you,
Thank
Your
you.
Honor.
Don't have to worry about this Florida case.
This is gone.
It's gone. Okay.
Thanks, sir.
Thank you. Yes, sir.
Judge, on the arraignment docket for 1:30, I have Russell Thorne,
Okay.
which is 24 CF 710. He is not present in the courtroom. I was reviewing the jail information, and it looks like he bonded out and was taken by an Alabama felony violation of probation.
Okay.
So he's likely in custody somewhere in Alabama. I would ask that the court allow me to enter a plea of not guilty for Mr. Thorne to see if I can find him.
Yes,
We've
sir.
already done one round of depositions in this case.
Okay, good.
Thorne?
So it's set for July 8th.
Yes, Your Honor, thank
Good.
you.
Thank you. Yes, sir, Mr. Koch.
I had two left on the docket. For the 130, last name Reeves, first name Hayward.
Okay.
Your Honor, I spoke to him early this morning around 8:30. I did file a waiver of appearance.
Good.
Formal charges were filed today, so we'll be entered not guilty and request to keep set for that 7-8 pretrial.
Yes, sir. Good.
And then, Your Honor, I have last name Celadonias, first
Okay.
name Daniel. Also been in contact, I filed the waiver requesting to be kept on that 7-8 pretrial docket.
Yes, sir.
I thought he was set for a bond hearing today, this morning. Yeah, he's on the 9 AM docket. He's on the 9 AM docket, he's not set for felony plea date till next week.
I apologize.
They did file the information, so I mean, if you want to go ahead and.
If I can, just,
That'd be good.
I should have set the bond hearing.
thank you.
You need your client to argue the bond hearing?
No, Judge. He got released.
But he's
from
out, right?
He got released from custody, and he actually is,
Dumb question.
yeah, he's good.
Okay.
Thank you, Judge.
Okay, thank you.
I have, Michael Orlando in Fort Worth, Mass.
Your Honor, I went up to 3A. Mr. Orlando's not there. That's my assistant. He called our office one time in the month of April about something unrelated. I don't know where he's at.
Okay. KP's is issued for him. First appearance judge will determine the bond.
I have, Alexander Robinson, who's unrepresented, but still out. Finish you out.
Judge, I believe on that one, there's a bunch of correspondence from the mental health pretrial services, and you
Okay.
continued that in an email. But I don't know if there was another date set.
Okay, so there was an email from,
From Kelly at pretrial services, they were concerned he was an inpatient.
okay, do we want to continue it?
Yes, Judge.
Okay, so Robinson is continued 1 week. Anything else, 1:30? Okay. Y'all want to break until 2:30? Okay. We're in recess until 2:30. Thank you.
All right.
Thank you. Please be seated. Okay, from shortest to longest, what do we want to do on the 2:30, Doctor?
All right. Judge, I have a quick plea.
Please.
Mr. Adrian Rico Garcia.
Okay.
Sit to read it, okay. I saw that on the list.
And counsel on Zoom, I'll take you right after I take Mr. Koch's plea.
Judge, I'm sorry, can you pass me up and can you take the other
Okay?
side?
I will pass it up. Mr. Nopes, are you ready?
Yes, sir.
Please.
My name, Judge, is Mr. Seawright present?
Mr. Seabright? Yes, sir. Come on to the lectern.
Judge, yesterday, Ms. Bergman and I had a conversation, and she was willing to offer to Mr. Seawright. I did try to call him yesterday, but none of the numbers I had for her. But, so it'll be the first time he hears the offer, but the offer is to admit that you violated your probation with the understanding that you can be reinstated, but that you have an additional requirement that you either stay employed or if you're unemployed, you seek to find a job 5 times a week until you get a job.
So 5 applications a week and obtain gainful employment or do 5 applications per week, and there would be a $100 cost of prosecution for each of the 2 cases, so it'd be $200, and then a $250 public assistance fee. That's the offer?
Yes, Judge, and you have to complete all original requirements.
Okay, right, it'd be the original requirements, and then his adjudication would be what?
He was, I believe he was previously adjudicated. Just give me 1 second.
Excuse me, Judge.
Yes, sir.
I have a job. I just came from work.
Good.
I didn't know if that was...
That's great. Then you would, as long as you have gainful, meaning financial employment, then you would fulfill that condition.
Okay.
And whatever the original adjudication was, whether it was a withhold or whether it was guilty, that would remain the same. So do you wish to accept that state's offer?
Yes, sir.
Okay. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Do you understand that if I accept that offer, that you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you?
Yes, sir.
Okay. Have any questions for me or Mr. Nopes or the state?
No.
Okay. Mr. Seawright, I do accept your plea. Your current supervision is reinstated and modified so that you need to maintain gainful employment or perform 5 job applications per week. You'll need to pay the $200 cost of prosecution, $250 public defender's fee. Since it's a reinstatement, all the original terms of your supervision continue. And the adjudication was?
He was previously adjudicated, Judge.
Okay, so you're adjudicated guilty.
And it is a downward departure based on an uncoerced plea. However, we would note, we spoke with probation, and one of the main reasons that we're doing this, even though he scores DOC, is they said that he's maintained some stable living arrangements now and is doing fairly well in Crestview supervision.
Yes, sir. Yes, ma'am.
Good, Mr. Seawright. Thank you, sir.
Thank you.
Yes, sir.
Done?
You're done.
May I approach the score sheet?
Yes, ma'am. Thank you.
Thank you, Your Honor.
Thank you, Mr. Nopes.
Have a good day.
You too. Mr. McKeviges. Mr. McKeviges, are you on? Good, thank you, sir.
How are you doing today?
I'm doing well. How are you?
I'm doing well. Doing well, thanks.
Yes, sir. So what are we doing on your case?
Okay, on my case, the last time we were in court, my client entered a no contest plea, an open plea to the court. The reason behind him doing that was because the state attorney's office with the information they had at the time.
Okay, let me stop you one second. Is your client here?
I believe so. I believe he's present on.
Mr. Vincent? Oh, good, okay, good. Yes, sir.
Yeah.
Please continue.
Okay. And we have reached an impasse because my client, Mr. Vicencio, has no prior record, and the state with information they had could not come off of an adjudication of guilt. That had to do with the impression the state had that there was a firearm involved in a prior case that was, and I apologize, I misspoke about the prior record. I believe that the prior case was pled down to a misdemeanor. The state was under the impression there was a firearm involved. Your Honor, the court took a plea from a no contest plea from Mr. Vicencio, and we set the case for today, and the understanding was that if in fact a firearm was involved in that prior Illinois case, that he would be adjudicated guilty and become a convicted felon. If there was no firearm in the Illinois case, that he would receive a withhold of adjudication and a probationary sentence. And so we're here today. I reviewed the Illinois statute that Mr. Vicencio was originally charged under, and it is not a statute that involved a firearm. And then yesterday, the state sent me in discovery the report from the arrest, and in fact, in the report, there are no allegations of a firearm.
Okay.
And Mr. Vicencio's assertions that he's never touched a firearm in his life, you know, at least in this circumstance, in the case where he was charged with a crime in Illinois, he was not alleged to have been in possession of a firearm.
So what would the sentence be?
I believe that the agreement was 36 months probation, and the state was wanting an adjudication, and we were asking for the same sentence, but with a withhold of adjudication.
Okay, so it'd be a withhold, 36 months probation, court costs $40 per month, cost of supervision, any other terms of the plea agreement?
There would be substance abuse evaluation and treatment, and then, of course, anger management.
Okay.
And the state still would like to be heard on the adjudication issue.
Okay, okay, any other terms other than the adjudication? So 36 months probation, court costs $40 per month, substance abuse, evaluation, treatment, anger management.
And, of course, no alcohol or controlled substances around your analysis. We don't feel like that clearly alcohol, I'm not sure about an illicit substance, but clearly alcohol is an issue and a factor in this case. So that needs to be part of the sentence.
Okay, Mr. McCaviage, is it, other than the adjudication, is that what your understanding of the plea agreement would be?
Yes, sir.
Okay. Yes, sir. Mr. Snow?
As far as the adjudication is concerned, clearly he was charged with a felony in Chicago, and the way that it was worded, it sounded like there was a felony. It clearly was reduced from a felony to a misdemeanor. And then when you have the behavior that's so similar from the night here in Florida, that this gentleman exhibits sort of a disdain for law enforcement, or just flat out no respect at all for law enforcement. And if you are going to try to hit them, if you read what the allegations were in Chicago that night, they're the same. He's trying to hit the officer when he's being detained.
With his head,
With
right?
his head, and this, you know, saying things like, I hope you get shot, I hope you die, and then the things that he said to Deputy Carter, I feel like based on that temper and alcohol, I think the community would be safer if he wasn't allowed to own a firearm. It'd be safer if he was a convicted felon. And he's already gotten the same behavior, got it reduced. Now here he is, he actually hit Sergeant Carter in the face and knocked his glasses off. right? And now he's hit someone and he's asking for a withhold when this is the second time. Why would he be entitled to a reduction 2 times, 2 bites of the apple? And it's such, the behavior is so consistent that this state would strongly ask for an adjudication of guilt in this case.
Okay. Mr. Kemp, yes, sir, you get the last word.
Thank you, I appreciate that, Your Honor. Essentially, the first thing I'd like to point out is just that, Mr. Vicencio's definitely, at this point, he understands, what appropriate behavior is, and he's definitely terrified of, and it's still a pretty severe, situation that he's going to do 3 years probation, and on a felony charge. And if he violates probation, he has the potential to be sentenced to prison. He's terrified, and he's otherwise a law-abiding citizen aside from this one prior incident. Understandably, it doesn't display the best behavior of a citizen, but lifelong consequences are pretty extreme. And just, I think if we go back and listen to the transcript from the hearing in which Mr. Vicencio entered a plea, my understanding, and I'm surprised that Mr. Snell's giving an argument here, I assumed it would be stipulated, because the understanding in that hearing was that it was a plea straight up to the court, and the only question we were addressing today was whether or not there was a firearm involved in the prior case. And the understanding was that if there wasn't a firearm involved, that the court would impose a withhold of adjudication, and that if there was a firearm involved, then he would need to become a convicted felon, and he would be adjudicated guilty.
When was the incident in Chicago? How long ago?
2017.
Okay, thank you. Thank you, sir. Okay, Mr. Vicencio, certainly concerns the court a great deal as far as the conduct with the law enforcement. When I was doing my homework and read through, again, the arrest report here, certainly hugely unacceptable behavior. However, I agree with you and I agree with your attorney as far as I stated what was going to be dispositive on my ruling was about the gun. I'm going to stick with that. The length of probation gives me a comfort level with that, because if you violate probation, you're going to be looking at, some severe consequences. So adjudication is withheld. You're sentenced to 36 months probation, and that's to run concurrently, run together on the 2 counts. You'll need to pay the court cost, $40 per month cost of supervision, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today, enter and successfully complete the anger management course. You'll have no alcohol, no medications without a valid prescription, submit to random UAs and random breath tests. So since Mr. Vicencio is here via Zoom, Mr. McCaviges, he's going to have to report to probation tomorrow morning at 8 o'clock, okay?
Is that via telephone?
No, sir? Where do you reside, Mr. Vicencio?
I'm in Chicago.
Okay.
He's got to report in person because we have to have the $100 fee paid in order to transfer him back to Chicago. He's an out-of-state transfer. He will have to show here in person, pay the $100, and then we have to do the transfer.
Mr. Vicencio, you have to appear here live no later than noon on Monday, okay? And because you've got to get the approval from probation here before you leave.
Can we get his phone number, Your Honor?
Mr. Vicencio, what's your telephone number?
815
no later than noon Central Time, Monday.
Where's this at?
13 Kelly Avenue,
13 Kelly Avenue.
Fort Walton Beach, Florida. The phone number is 850-344-0005.
I'm sorry, 344-0005. 0005.
Yes, sir.
And the court has no
Okay.
objection.
The court has no objection to Mr. Vincencio transferring supervision once he gets the okay from probation here. Right. Thank you. Thank you both.
Thank you, Mayor, I have nothing further.
Thank you, Mr. McAvich.
Have a wonderful rest of the afternoon.
Thank you. You too. Okay. Back here. Yes, sir, Mr. Koch.
Judge, I don't have anything further. If I could be dismissed?
Yes, ma'am. Thank you so much.
Judge, we have Mr. Adrian Rico Garcia.
Okay.
You too.
Thanks, Ms. Barrickman.
Good afternoon, Your Honor.
Good afternoon, sir. Yes, sir.
This is Mr. Adrian Rico Garcia in 22 CF 2966. This will be admission, and I just have a brief note. Mr. Garcia is crying because of tears of joy, Judge.
Okay.
He's very, very thankful for this opportunity. Thank you. Get you some right there. Yes, sir. It is 5/16/24. Excellent. Your Honor, this would be an admission. It would be an adjudication of guilt. 160 days in the Okaloosa County Jail with credit for any time served. There's $100 cost prosecution, the $150 in defense costs, and it'll be a revoke and termination of probation, if I may approach with the plea form.
Yes, sir. Thank you. Mr. Rico Garcia, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You can put your hand down. Did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
I'm very blessed. I'm happy, yes.
Okay. Did you sign the plea agreement?
Yes.
Mr. Rico Garcia, do you understand that if I accept your plea, and I'm not the federal court, I'm not in charge of deportation or anything, but if you are not a U.S. citizen, and I used to say this may subject you to deportation, but there were some appellate cases that came along that said, I'm supposed to say, do you understand that this shall subject you to deportation? Again, I'm not the one that pulls that trigger. That's the federal side of it. But do you understand this shall subject you to deportation?
Yes.
Okay. You furrow your brow. I'm not doing that. I'm not putting anybody on notice of that. I'm just following what the appellate courts tell me I have to say.
Yes, that's fine.
Okay.
That's fine, Your Honor.
Do you still wish to enter the plea?
Yes.
Okay. You're adjudicated guilty. You're sentenced to 160 days in the Okaloosa County Jail. That's to run concurrently on each count at the same time, also with credit for all time served. You'll need to pay the $100 VOP fee, $150 public defender's fee. Your prior supervision is revoked and terminated. How long will you need to pay the financials after you get out of jail?
Well, I know the place that I was working at, Chipotle, I'm pretty sure they're still going to offer me my job because they even asked me if I want to become a manager. And I know that as soon as I get out, the owner of Mi Gente, this guy owns 2 stores, one in Fort Walton and one in Destin. So I already have a place to go and the job. So as soon as I can start working, I'll be able to, as soon as I get my income, I'll be able to start paying.
Why don't we say 6 months, okay?
Yeah.
So if you fail to pay those financials within 6 months, then they will go to a civil lien or judgment. Okay, nothing criminal, civil.
Yeah.
Okay?
Yes.
Thank you, sir.
Yeah.
And Judge, my next case, or my last one, would be Ruben Stokes is the last name. And just to give speaking with the state, we did agree on Mr. Stokes, so it shouldn't be it's not a hearing, just to clarify.
Judge, we have Michael Orlando, who was on the 1:30 docket, and he's sitting up for Judge Ketchum's.
Okay, come on, Mr. Orlando.
Wrong court.
Yes, sir.
Judge, he's represented by Mr. Kleins. I believe he has contact information from Mr. Kleins. We would acknowledge the receipt of a one-count information, waive its formal reading, and enter a plea of not guilty. We would ask the court to withdraw the KPS if the court issued one earlier.
KPS is withdrawn, so I'll see you back. This is a new case, right?
Yes, Your Honor. It will be 7-8 for pretrial.
Good. I'll see you on July 8th at 9 o'clock. If the state offers you something that you want to accept before that date and you want to avoid about 300 people, talk to Mr. McKinney about setting a hearing before then, okay?
Okay, sounds good.
Otherwise, July 8th, 9 o'clock.
Okay, thank you.
Thank you.
Already spoke.
Thank you, ma'am. Yes, sir.
Yes, Judge, it's Mr. Ruben Stokes.
Hey, Brian. Hello, Mr. Stokes.
We're here in 22 CF 336 and 23 CF 1823, Your Honor, for sentencing. Speaking with the state, we have worked out a resolution in this matter, so that's why we won't have a hearing. I do request, though, that after we do enter the plea, that my client could just read, he worked hard he wants to address this court. I want to give him that opportunity.
Absolutely.
I know we can do that.
Yes,
So
sir.
speaking with the state, Your Honor, we'll be admitting to the violation in 22 CF 336 and plead no contest to the 23 CF 1823. It will be 11.29 months in the Okaloosa County Jail. And to be clear, this will be no prior credit time. This will be a fresh 11.29 months, Your Honor. Once being released, he will be followed by 2 years of drug offender probation. And that, of course, has the curfew from 7 p.m. to 7 a.m. And then after those 2 years of drug offender probation, it's followed by 3 years of standard probation. And of course, this agreement has the $100 for the VOP cost of prosecution and the $515 in court costs, Your Honor.
Okay.
And that program, just for clarification from my point of view, has the substance abuse training and work. Is that, Mr. Koch, is that correct?
Yes, Your Honor, and if I may, Ms. Dana Clark, if you may stand up, she runs the Anchored program at the Okaloosa County Jail.
Good. Yes, ma'am. Thank you.
And she was so excited to be here to meet Judge Brown, me, the state attorney, and big advocate for my client, and she's running the program there. So I wanted to just tell her thank you for coming and what she does at the jail.
Yes, ma'am. Absolutely. Just recently, the jail's been getting a lot of credit. You know, for one thing, you had a newspaper article and those things that talked about the program that you're doing and the great job. But then after that, maybe a few weeks after that, we had testimony here in the courtroom that talked about that, and the inmates talked about the way that they were benefiting from that. And so that is fabulous. I have never heard that before. I've been on the bench for 14 years. Never heard, that degree, that depth of help for inmates that are in our jail. So thank you. God bless you. Thank you so much for that.
I believe she was just recently awarded that Liberty Award from the Bar Association as well. So
That's awesome. Congratulations. Thank you, ma'am.
Yes, you did. And
Okay, so, credit. Mr. Stokes.
Sir.
So you're adjudicated guilty, you're sentenced to 11 months, 29 days in the Okaloosa County Jail with no prior credit, so that starts today.
Yes, sir.
Followed by 2 years of drug offender probation, 7 p.m. to 7 a.m. curfew, followed by 3 years of standard probation. You'll need to pay the $100 cost of prosecution, court costs, $250 public defender's fee, $40 per month cost of supervision during your supervision. Stokes, I wish you the best, sir.
And-
Thank you.
And Your Honor, my client just read his
Oh, yes,
prepared
sir.
letter.
Please.
I'm going to get out of your way so you have the floor.
I appreciate it. I apologize, sir.
No, sir, no reason to apologize.
I came here prepared to plead to the bench, so that's what's referred here.
Yes, sir.
So allow me to begin by saying thank you for this opportunity to plead to your honor. I stand before you as a humble man and a renewed child of God. Before now, I really never knew what it truly meant to be humble, nor even a child of God. Before now, I've always had issues trusting anyone in authority positions. Like many children, I began life in a dysfunctional family setting. Both my parents divorced due to an affair my mother chose to have. During that affair, I was conceived. My birth certificate father only found out that I was his offspring during an argument. They both agreed that I was the mistake that basically ended and caused the divorce. By the time I turned 12 years old, I had been molested by an 18-year-old babysitter at age 5, by my uncle at ages 8 to 9, by a Boy Scout leader at age 9, and finally, my mother and stepfather allowed my landlord to use me as a sex toy from ages 9 to 12, just to pay half the rent. It wasn't until December 24th, 1986, that I became incarcerated in a state hospital for children. My mother decided she no longer wanted me wanted her imperfect son, and how my sexual favors to pay the rent was coming to an end. I remained there from ages 12 to 15. This was my first lesson in living with boys only. On December 24th, 1989, I was transferred to a children's foster group home where I remained till I turned 17. At 17, I was released to the streets to either survive or die in a dog-eat-dog world. I never knew where to turn nor who to turn to or trust. Until this point, I had no one willing to be a positive role model or want to teach me how to be a man. I had finally found someone I thought I could trust. Turns out that because became a false hope. She introduced me to PCP, acid, angel dust, THC, meth, alcohol, and the list goes on. She kept me dependent upon her for my next fix. If I wasn't in her bed pleasing her, I was in someone else's bed, someone else's pleasing him or her. It was all I knew and understood. She was finally arrested and I ran away. Starving, detoxing, and homeless, I decided to sign up for Job Corps. When I became accepted, I learned my second lesson in living with other young men. This was my second incarceration, but this time I chose it. Already knowing how to live with other men, I found I fit right in. I finally graduated Job Corps with a GED and a certified certificate of combination welder with a delayed entry into the Navy, and met my wife in 1984. Had a child in 1985, then another in 2000. My mother died in 99, which sent me spiraling down a rabbit hole of no return. I had no clue how her death would affect me, so by the time my second daughter was born, I was living a lie of some sorts. Alcohol and meth had become my trusted friends and allies. I always knew where I stood with them. I felt God had it in for me. And He wasn't going to let up. I soon ran away from life, only to become homeless during the winter, and in doing such began committing burglaries to stay warm and to feed myself. When I was arrested, I learned a third lesson in living in close quarters with other men. In 2001, I became incarcerated again as a result of my poor decisions. I could have gone home to my wife and been a proper father, but I didn't, and not because I wanted to. I didn't return home because, one, I didn't know how to be a father or a husband. I didn't even know how to be a man. I was still a child in a man's body trying to play God with my own life. In jail, I had to learn how to be a man real quick, and that's when my mental health became an issue. Between trying to sort things out, the mental breakdowns and suicide attempts, my life became a blur after finding out my wife died in 2004 from alcohol poisoning. While was on parole, the man of my birth certificate, the father I've only known, died of cancer in 2011. Again, I sank deeper into depression. I hid in my apartment away from society, afraid to connect with anyone that God might want to take out of my life. June 15th, 2015, I was released off of parole for good behavior. So I chose to leave Missouri and try something new. Everything was going well till COVID-19 struck. I lost my older sister to diabetes in 2020. Then my baby sister, April 1st, 2020.